Chapter 9 deals with the federal judiciary. This is the Supreme Court and the lower federal courts that were established by Article 3 of the U.S. Constitution. The photograph here is of Morrison Waite. Arguably, he was the most obscure of Supreme Court Chief Justices. He served from 1874 until 1888. As an Ohioan, I have a particular like for Morrison Waite, who is a fellow citizen of that state. This is John Marshall. John Marshall wasn't the first Chief Justice of the U.S. Supreme Court, but he's probably the most significant because he is the justice who helped create the modern Supreme Court. Now you might say modern, he started in 1801. I mean in the sense of that it was John Marshall who first claimed the power of judicial review. Judicial review is not in the U.S. Constitution, but judicial review, or the practice of allowing the Supreme Court to overturn federal laws or federal actions that run counter to the Constitution, was very important because it established the courts, and especially the Supreme Court, as being equal to, in power, the other branches of government. John Marshall had been Secretary of State under John Adams. He was a Virginian. He really didn't like Thomas Jefferson, the person who replaced John Adams as President of the United States. And when the Jeffersonians, they called themselves Republicans, though they're often called the Democratic Republicans now because they are the ancestors of the modern Democratic Party. When they took over, it was the first peaceful transition of power in American history. And so there was kind of, they were writing the book as they were living it. And one of the things that happened is that John Adams had appointed several judges right as he left office, and left to the new Secretary of State to actually give those judges their commissions. And Jefferson's Secretary of State was named James Madison, who later became president. And Madison refused to do this on orders of Thomas Jefferson. And because they had been nominated by the president and confirmed by the Senate, it was generally accepted that then they take office. That's what the Constitution says. It doesn't say that you actually have to receive a document to say that you are. Although it's generally practiced now that you don't become a judge until you receive an official judicial commission. Well, what happened is that one of these judges, William Marbury, tried to get Madison to go ahead and appoint him by filing what's called a writ of mandamus. A writ of mandamus is an order to a judge or any government official to actually carry out his official duties. And it's the official duty of Madison to appoint these people to the judgeships they had been confirmed to. However, Jefferson and Madison had already said, no matter what the Supreme Court tells us, we aren't going to do it. So Marshall had a tough choice. What is he going to do? Well, what he decided to do was to strike down the Judiciary Act of 1801, which gave the courts the power to issue writs of mandamus. And by doing this, he claimed a power that the courts hadn't yet had, but he didn't actually require Jefferson and Madison to do anything with respect to Marbury's claim. And by doing this, he increased the power of the courts, which the Federalists still controlled, by giving them the power to strike down federal laws. But he didn't come into enough direct conflict with the new president that the new president would be able to strike out against him. kind of some legal finesse there, and it led to what we now see as judicial review. But this leaves us with a question as to whether the courts really have this power. I mean, I guess they do have this power. They exercise it fairly regularly. The Supreme Court only invalidated 2 federal laws, including the Judiciary Act of 1801, prior to the Civil War. But it's not uncommon now for them to invalidate a federal law every year or so, sometimes more. That gives you an average of more, but the typical year, it's 1 or 0. Now, the Supreme Court didn't always deal in the same cases that we see them deal with today. In fact, early on, the big issues that came before the Supreme Court was the division between national authority and state authority, so-called federalism cases. The Supreme Court doesn't deal much with federalism anymore. The national government won the battle over federalism, and it's very rare that a successful claim of states' rights is made in court. It still does happen sometimes, but it's not the main focus. And then between the late in the first half of the 19th century, up through 1937, the main thing that the Supreme Court dealt with was government regulation of the economy. The court for most of this time was very strongly in favor of business, or at least of the inability for states to regulate businesses, especially businesses that were engaged in interstate commerce. After all, the national government is in charge of interstate commerce, but the question becomes, well, what if the U.S. government isn't regulating commerce and the states want to, or they see a problem? The minimum wage was an early problem. The number of hours that employees were forced to work was an early problem. And the courts generally said that anytime the U.S. government didn't pass a law dealing with interstate commerce, that the states were required to not pass laws of their own. And then finally, in the period after the Second World War, the Supreme Court has become much more involved in issues of civil rights and civil liberties. And so when we see them requiring things like the Miranda warning and invalidating convictions of criminals, or striking down laws that regulate freedom of speech. These are all things that the Supreme Court has only started to take an interest in perhaps the last 100 years. And so, when you say, well, what are the famous early First Amendment cases? You don't really see many during the early 1800s. And it is during this time that the Supreme Court has started to say that laws passed by state governments need to comply with the U.S. Constitution. Through much of early American political history, this wasn't the case. The Supreme Court invalidated 2 federal laws during the entire time between 1801 and 1860 at the start of the Civil War. The 2 cases, Marbury versus Madison, which we've already mentioned, we generally accept as being a great Supreme Court decision. On the other hand, Dred Scott v. Sandford, we generally look at as being a horrible decision. In general, the early Supreme Court made decisions that were in favor of the federal government and federal government power. And so they struck down state laws. In McCulloch versus Maryland, they struck down a law which would have taxed the Bank of the United States. However, in Dred Scott v. Sandford, they took the side of the South, saying that just because a slave was brought to a free state or a free territory did not render that slave a free person. Basically, it enforced slavery everywhere. States only had the power, once they became a state, to force somebody who owned slaves to leave the state. It didn't affect the status of the person who was a slave. So 2 decisions, half were right, half were wrong. And so, giving unlimited power to lifetime appointed officials is a two-edged sword. And so when people look at the Supreme Court as being a source of good, or a potential source of good, we should always be aware that the power to make good decisions is also the power to make bad or even evil ones. You see here a chart that gives you the structure of the United States court system. It's a little bit more detailed than you're going to need to know for this course. You see at the top is the Supreme Court, and below, at the far left, you see the 12 U.S. courts of appeals that are divided into circuits or regional parts of the United States. In the middle, you see the so-called Federal Circuit. The Federal Circuit is a specialty court that deals with particular types of cases. You'll see the cases from the Court of International Trade, the Court of Federal Claims, and the Court of Veterans Appeals all go to the U.S. Court of Appeals for the Federal Circuit. And then something we're not going to look at is the U.S. Court of Appeals for the Armed Forces. But you'll note that appeals of decisions of military courts also go to the U.S. Supreme Court. So what we will say in this course is that there's 13 courts of appeals, the 12 that are based on the regional circuits and the one that is the Federal Circuit. We'll also note that there's 94 district courts. Those are the federal trial courts where most federal cases begin. And in addition to that, there's several other courts at the district court or trial court level that aren't district courts but deal with specific specialized areas. Note that the tax court, the federal claims court, and the Court of Veterans Appeals are not courts where the judges have lifetime appointments in the same way as they do at the district courts. Interestingly enough, the Court of International Trade, they do have lifetime appointments, even though we treat them as not being part of the district court system. This slide shows us the jurisdiction of the federal courts. There's 2 types of cases that go to the federal courts. In fact, over 90% of all court cases brought in the United States are heard by state courts. So, people say don't make a federal case out of it. Really, you can be executed by a decision of your state court. So I don't know how you can get more, high profile than that. But in any case, the jurisdiction of the federal courts are federal questions or diversity jurisdiction. Federal questions are when the United States is a party in the case. They either bring a case or they are responding to somebody else suing them, which is very limited when you can sue the U.S. government. But if it involves a federal law, it involves the U.S. Constitution, if the U.S. government is either charging somebody with a crime or suing somebody or being sued, these are all cases that automatically go to federal courts as federal questions. Now, on the other hand, sometimes, and very rarely actually, when people from 2 different states or businesses from 2 different states or a business from one state and a citizen of another state are in a legal case against each other, or 2 states are debating things like boundaries or water rights or the rest, these are called diversity jurisdiction cases. Now, quite often, if you are the resident of one state and you are sued by a resident of another state, you don't have that opportunity. Some of you might have credit cards. If you look very closely at the fine print on your credit card, you actually waive the right to have your case heard in federal court, and instead they specifically designate a state court in the state where the credit card company is domiciled to hear the case. I'll bet you a dime against a dollar that the top contributors to the campaigns of state court judges in those states are the credit card companies. Anyway, look next time you fill it out, you'll see that. Well, you can waive this, so you can actually have your case heard in state court, but under the Constitution, you have the right to have your case heard in federal court unless you waive that right. Now, the next slide actually deals with the district courts. It gives a little bit of data on the district courts. You see that some states only have one district court, while other states have as many as 4. You'll also see that there are that they have jurisdiction over both criminal cases and civil cases. And I have a quick definition of what civil versus criminal cases are. Recently, I have become very interested in the courts of appeals. There are 13 courts of appeals we saw on the slide before that we're going to be dealing with a total of 179 active judges. They generally sit in 3-judge panels. And in fact, quite often, 1 or 2 of the judges on a 3-judge panel won't even be Court of Appeals judges. They'll be district court judges or retired or semi-retired judges called senior judges. And it's so, there are so few of these Court of Appeals judges when compared to the total number of cases brought to the Court of Appeals that most people consider themselves fortunate just to get 3 judges to hear their case. They review the district court decisions. They have what's called appellate jurisdiction, which means they cannot hear any trials. They can only hear appeals of decisions made at the district court level. Now, there's 11 separate geographic regions called circuits. A 12th circuit is assigned to just the District of Columbia. Not a lot of cases, but some of the most important cases are to the Court of Appeals for the District of Columbia. And then the 13th is that specialty court, the Federal Circuit that we talked about earlier. And then finally, the highest court in the country is the Supreme Court. It has 9 judges, and they sit together, all 9 judges, to hear cases. They're not in separate panels. Most of their cases they have what's called discretionary jurisdiction. They can either take the case if they want or refuse the case if they don't. If they refuse a case, whatever the Court of Appeals said is final. There are a couple different types of cases, like suits brought between 2 states where they have to hear the case as a trial court. They usually appoint a judge, a former judge or a current judge, to hear the case and take all the evidence, and then they make the decision. This is rare, sometimes less than once a year. When Georgia and Tennessee and Georgia and Florida fight over water rights, then the case goes to the Supreme Court directly. But commonly, the decisions are based on appeals to the Supreme Court. Becoming a federal judge is kind of a good gig. First of all, you have lifetime tenure. You never have to be reelected or reappointed. It's probably the most important aspect of being a federal judge. You become a federal judge by being nominated by the president and confirmed by the Senate. This is a photograph of Supreme Court Justice Amy Coney Barrett, Donald Trump's final nominee to the U.S. Supreme Court. She had previously served on the U.S. Court of Appeals for the 7th Circuit. which is Indiana and Illinois and Wisconsin out that way. Originally from Louisiana, she served as a law clerk for Supreme Court Justice Antonin Scalia. She was a law professor at Notre Dame Law School, where she captured the attention of conservatives who wanted her to be nominated to the Supreme Court. She's widely seen as a conservative in the mold of Scalia, and Trump was able to get her confirmed just a week before the election. This was a very, very quick turnaround after the death of Ruth Bader Ginsburg. And a lot of people credit the Barrett nomination with moving the court to the right. This is a photograph of Ketanji Brown Jackson. She is the newest justice on the U.S. Supreme Court, starting in the summer of 2022. Formerly, she had served on the U.S. Court of Appeals for the District of Columbia, which is often seen as a stepping stone to the Supreme Court, though the U.S. Court of Appeals for the District of Columbia is not higher ranking than any of the other Court of Appeals. She was born in Washington, D.C., but grew up in Miami, and her father was actually the chief attorney for the Miami-Dade School Board. She went on to graduate from Harvard Law School. She served in numerous positions. Perhaps the highest profile of these was that she was the vice chair of the U.S. Sentencing Commission, where she had been an advocate for reforming sentencing. She had been a district court judge and a court of appeals judge, and she'll be the first justice who served for a time as a public defender. She's widely seen as liberal, probably, by most accounts, the most liberal justice currently on the court, and she's President Biden's first nominee. Interestingly enough, she's the first African American woman to serve on the Supreme Court. When we talk about judicial decision making, we're often left to say it depends an awful lot on the court and the level of the court in which you're dealing. The federal court system has a tremendous caseload. The district courts handled many, many cases. In 2017, 368,000 criminal and civil cases. Of these, 60,000 are appealed to the courts of appeals. The Supreme Court, on the other hand, decides fewer than 100 cases, about 1% of the appeals it receives, or what they actually call petitions for certiorari. They receive about 8,000 a year, and in recent years it's even been maybe about 80 cases that they've heard a year. So obviously the Supreme Court has a lot more time to give consideration to the cases. The U.S. Supreme Court does not actually consider all 8,000 cases which are appealed to it. The Supreme Court has what's called discretionary jurisdiction. In 1925, the court persuaded Congress to change the rules about granting access to a hearing by the Supreme Court. Now, if you wish to have a case heard by the Supreme Court, you need to file what's called a petition for a writ of certiorari. This is a request that the court order a lower court to send it the records of the trial in question. In practice, what it means is it's a petition to get the Supreme Court to consider a case on its own merits. The Supreme Court receives thousands of requests, but it actually only chooses a few. And in order for a case to be considered on its merits, 4 Supreme Court justices need to agree to hear the case. Now, how does this work? First of all, you're not likely to have your case actually considered by a Supreme Court justice at all. The first person to consider your case is likely one of the law clerks. Most Supreme Court justices have 4 law clerks. One of these law clerks, they donate to what's called the cert pool. The cert pool actually writes a legal brief for every single petition for certiorari that the court receives. They then they then collect these, and each justice receives a legal brief summarizing the issues of the case and why the court might take the case. Now, what happens is that the Supreme Court then gathers together in what's called a conference, and they consider each of the cases. The Chief Justice has what's called a discuss list. He has a list of cases that he wants to make sure are considered. Any justice can have a case at their own discretion added to the discuss list, and they can also bring them up during the conference, even if it's not on the Chief Justice's list. However, if a case isn't discussed at the conference, it just dies. But when it is discussed, the justices will then vote, and if 4 of the 9 ask for the case to be heard, it goes on to the court's docket, and it will be argued in favor of the court. Quite often, they consider what are called amicus curiae, or amicus briefs. This is Latin for friend of the court. And these legal briefs are arguments by people who are not actual parties of the case, whether the case should be heard or not heard by the Supreme Court. Once a case has been set for argument by the court, they often ask for the opinion of the Solicitor General. The Solicitor General is the person who represents the United States government in front of the Supreme Court. In addition, the Solicitor General's opinion on whether a case should be heard is taken into a lot of account. The Solicitor General has been called by certain people in the media and such the 10th Justice. The 10th Justice in the sense of just how important that office is. Notably, the justices never refer to the Solicitor General as the 10th Justice. So when you want the case to be heard, you file your petition for certiorari, you create a legal brief which argues first why the case was incorrectly decided at the lower level and why the Supreme Court should hear the case. The person who files the petition is called the petitioner. Then the side that won at the lower court level and doesn't want the case to be heard files a legal brief that argues against the granting of cert. This person is called the respondent. Now, once the Supreme Court has decided to hear the case, they rebrief, as they say. The petitioner has a brief on why the decision should be overturned on its merits, and the respondent then replies on why the case should be upheld on its merits. The legal briefs are very critical in the decision of the case. However, they actually have what are called oral arguments after this. Oral arguments take about an hour, evenly divided between the two sides, and they argue in front of the court. Following oral arguments, the justices hold another conference where they decide the case. They actually discuss it and then vote. After the vote, the Chief Justice, if he's on the winning side, or the Associate Justice who's been there the longest and is on the winning side, will assign the opinion to somebody who also voted in favor of the decision to write an opinion that justifies the decision. And since the Supreme Court only hears about 80 cases a year, the opinion is very important because it teaches and tells other courts how they should interpret the decision of the Supreme Court. The opinion of the court then becomes the explanation for what the case means. Now, if you disagree with the opinion of the court and you disagree with the decision, you can write a dissenting opinion. If you agree with the decision of the court, but you disagree with the opinion, you can write what's called a concurring opinion to spell out why you would have decided the case the way you did. So how do we actually staff the federal courts? The Constitution says that federal judges shall be nominated by the president with the advice and consent of the Senate. So the president nominates judges, and they actually appoint judges. The advice and consent of the Senate, though, is something that must occur. The Senate does not have to consider any judge. Their failure to consider and give consent to a judge is entirely up to them, and when they don't do it, it means the person doesn't become a judge. We'll see in the case of Merrick Garland was actually nominated by Barack Obama to be a Supreme Court justice, and the Senate just decided they didn't want to deal with it. The President and the Senate carefully consider the nominee's political views. This is probably the most important and increasingly important element of the decision. Senators tend to pick people who would be acceptable, and sometimes there's a negotiation. Just because a president nominates a particular judge doesn't mean that that judge shares his views. In fact, quite often what you'll see is when the senators are from one party and the president is from another party, that what the president ends up doing is picking one of his guys and picking one of the senator's choices, balancing that out if they can't actually decide on just two people mutually acceptable. The selection process is also different depending on the level. At the district court level, senatorial courtesy is very important. The Senate doesn't even consider judicial nominees unless they've been signed off on by the senators from that home state. Remember, every district court is contained within a state. So those two senators must say it's okay for that nominee to go forward, at least by practice. That's not a law. At the appeals court level, there's actually a rule that every state in an appeals court circuit must be represented on the Court of Appeals. However, that does not mean that the senators actually get to block people. There was a tradition for many years where senators were allowed to block nominees that they didn't approve of. But at least in recent years, even when senators from a state disapprove of that home state Court of Appeals nominee, presidents have been able to go ahead and fill the courts. On the Supreme Court level, you will see that there's a rather elaborate hearing in front of the Judiciary Committee. All of these judges have a hearing in front of the Judiciary Committee, but at the District Court and Court of Appeals level, these are half-day hearings, sometimes with many judges at the same time. At the Supreme Court level, we're talking about usually a 4-day hearing with just one nominee, and you'll have the nominee take up 2 days of the hearing, and then people speaking in favor and against each nominee taking up another day or two. As I mentioned, the president takes the most interest in Supreme Court justices. The ideological nature of the candidate is by far the most important. President Trump, for instance, had made a promise to his supporters that he would pick only certain judges that had been vetted by conservative groups and approved of by conservative groups. And he nominated judges off of that list. Gorsuch was on his list before the election, and Kavanaugh is somebody who was placed on the list after the election, but was widely approved of by conservative groups. It can sometimes be a reward for past service, but you see more and more that the ideology is more important. With President Trump, neither Gorsuch nor Kavanaugh were close politically to the president, but they were close to the people who the president was trying to impress with the nomination. And it might help build political alliances, but you see in history that when this has been the main task, that these are the judges or justices that most often cause the president to regret the decision. You probably want to pick someone who's already part of your political alliance. So once the president's named somebody, the Senate Judiciary Committee schedules the hearings, as we said, about 3 or 4 days, usually 4 days anymore, and they make a recommendation to the full Senate. When the opposition controls the Senate, there's a lot of fighting. When the president's party controls the Senate, it's usually a predetermined outcome.